Okay, so this is the last section of lecture for week 1, and we're going to talk about paternity, and specifically paternity inside and outside of marriage, and the putative father registry, which most states have. Okay, so there are multiple ways to establish the paternity of a child. The paternity matters because we're talking about who's the biological father. We don't establish this for maternity because moms are there when it happens, right? We can identify who, when the kid's born, we can identify who the mother is because she's there, right? Okay. When we talk about sections like this, it is very gendered language. We may use language to be more inclusive to people who are transgender. So when I don't use that language, it doesn't mean that I don't acknowledge that is something that when dealing with an individual client, for instance, you may have a client who identifies male and uses male pronouns but is pregnant, and so understand that those situations exist. In the interest of time, I'm going to use gendered language. So when we're talking about paternity, we're talking about establishing who is the father of a child, and this happens in a variety of ways. 1, marriage. When two people are married, we presume that the husband is the father. Now, this is historical. From long before DNA, the law in most states favors two parents and favors that regardless of and including biology. So when two people are married and there is a child of that union, we are going to legally presume that the husband is the father. Now, as we all know, that does not mean that the husband is biologically the father of that child. So historically, it could be that presumption was irrebuttable. You're the husband, you're the father. That's not the case anymore. Most of the time, this presumption is rebuttable. Meaning that if specifically a DNA test is conducted, they can rebut the presumption of paternity in a marriage. But we're going to start with the proposition that two parents are better than one, and husband's gonna be it. Okay. The second is through an affidavit of paternity. So if two people are not married and they have a child, when they are in the hospital giving birth or shortly thereafter if it's a home birth, they can, and they are very heavily suggested to do so by the authorities in the hospital, execute an affidavit of paternity. So unmarried, this is the putative father saying, I believe I am the father of this child, so I'm going to sign a document that says I am. And that makes him the father. Sometimes we do that after a paternity test, sometimes we don't. But without that affidavit of paternity, we might have a lawsuit, and that lawsuit can be filed independently or it can be filed as part of a support motion. It can be filed by the state. So someone who goes in to seek, a single mother, let's say, goes in to seek benefits from the state can say, well, who's the father? Why isn't the father paying child support? In order to get support, you're going to have to try to find the father of this child because we're going to either make him pay you or pay us. And so whether it's a paternity lawsuit from the mother of the child or the state, a DNA test would occur, and a putative father could file an affidavit at this point. But typically, what happens is the DNA test occurs, and then there's a judicial determination. The DNA test came back, you are the father, and an order is entered to the parentage of a child. Why this is important is because this is the law, but it is not necessarily the truth. In not every marriage is if we're talking about biology, if we're talking about who a father is to a child or who a mother is to a child, biology really has little to do with it, right? But since the law does require certain things from us based on the biology of parentage, it does make a difference. But just because you sign an affidavit saying you're the father of a child doesn't mean you biologically are. Just because you're married to the child's mother doesn't mean you're biologically the child's father. And what happens is we get into dicey situations because we have biological rights, biological facts that give us legal rights. And then we have things that we do, like getting married or parenting a child, that can give us rights. And sometimes these things conflict. And before we get into the Lair case, where we see this brought to life with the putative father registry, I want to talk to you about a couple of cases that I will put in the links to this course that talk about the repercussions of this. Okay. So let's say we are in situation 3, where we have someone seeking paternity. So what do? They file a civil lawsuit seeking paternity. And what happens if you don't respond to a lawsuit that's filed against you? You lose by default. Does that apply to paternity actions? You bet. And I'm going to post a really sad story about Minnesota. And I don't know if this has changed. I'll see if I can find that. But a few years ago, there were several news articles about being a father by default. And what was happening is that mothers were going to seek benefits from the state, and they were getting caught up in this. Well, you have to figure out who the father is, or have to try. And so they would file a paternity lawsuit, the state would, against a presumed father who would not get notice. Now, how do you not get notice of a lawsuit? Well, you're poor, you move, you're incarcerated. All of the people who are marginalized in our society are the ones who are least likely to get notice of a lawsuit. And they're among people where this situation, if you think about it, if you're already poor to begin with, then the person that you have a child with is likely to be poor, and poverty begets poverty, and it's a really sad cycle. So the story that I'll post for you is about situations where the father was adjudged by a court of law to be the father because he did not respond to a paternity lawsuit and then lost by default. And so they were adjudged to be the father of the child by default. Now, in most states, you can attack a default judgment on the grounds that you did not get notice of it, or fraud, what have you. At the time, that was not the case in the state of Minnesota. And so there was one of the gentlemen who was interviewed in the story said, I never even slept with that woman. And the woman said, I didn't know what to do. I needed to feed my child. I needed to get these benefits, and the state wouldn't give them to me unless I gave them a name. And so now he couldn't, it was years later, he couldn't attack the default judgment. And so now he is the father of this child. And so he is responsible to support the child that not only he's not the biological father of, but he couldn't have been because he never slept with the child's mother. And the mother was in an equally sad position because she was impoverished, and she said, I didn't know what to do. So this is, I think, the first example really of some of the very sad situations that we can get in. I do think that default law has changed in Minnesota, but it illustrates how difficult some of these situations can be when you are part of an underserved population. Which brings me to the putative father registry. So if you've never heard of this before, this, much like service of process in the newspaper, which is the last resort for you to serve somebody, you serve it in Indiana Lawyers Weekly that nobody reads, and you put it in the classifieds in the back, and nobody's ever going to see it, and that's somehow notice of a lawsuit. It's kind of like the putative father registry. So putative, meaning supposed to be or might be, from putative spouse a moment ago. A putative father registry is where you can essentially file a document that says, I think I might be the father of a child. I don't know, there's not been a test, but I think there's a kid out there who might be mine. So most states have putative father registries. Where you can file, and it essentially puts the mother and potential adopters on notice if you think you are the father of a child, in order to protect your rights to that child. And it's great. How many people who are in a situation to father a child even know this exists, and then on top of that know that they might be a father? I don't have any data on how often it's used. I don't know anyone who's ever used it. I don't know many people who even know it exists, but it's a legal thing. And we're going to talk about it because it does exist to protect the rights of fathers. How effective it is, I don't know. And it certainly doesn't protect anybody who has no idea that they're the father of the child, because you can't file unless you suspect you might be. And I suppose that you could file with every relationship you've ever had. I don't know anybody who does that, but I suppose it's a possibility. Okay, so we talked about parentage, and now we're going to talk about the putative father registry, and the two are really linked. So the Supreme Court case on it that we are going to look at is on 859. It's Lair versus Robertson, 463 United States 248. Supreme Court case on paternity, parentage, father's rights. So, woman has a child with man, and they are not married. But the man knows she's pregnant, knows she has a child, is in the hospital with her, but does not support the child, does not have a relationship with her, but he knows he is in a relationship with her, having sex with her, and she had a child. He knows that. So the child isn't hidden. Okay. Child is 8 months old. Mom marries someone else. After the child is 2, and they've lived together as a family throughout this time period, let's call him stepdad, wants to adopt the child. And so they go through the process of adoption, and the state puts its seal of approval on it. And part of that process, when the adoption happens, is that they have to check the registry. So when an adoption happens, you have to check the putative father registry to determine whether or not there are any paternal claims on this child that have been put on notice. So the first guy lived in a state with a putative, the biological father child lived in a state with a putative father registry. He did not put his name on the registry. Before, I want you to think for a second. You are all very educated people. You all have at least 1 degree already, if not more. You've already had at least a year of law school, if not more. Did you know this was a thing? And if we, in our privilege, our understanding, our education, our resources, if we don't know it's a thing, many other people are not as well. But he didn't enter his name in the registry. Okay. So what's at issue in this here is that at some point he got wind that the stepdad wanted to adopt the child and filed lawsuit and saying, I am the biological father. I want to step in and stop this adoption from happening. Let me do it. And the court in this case was determining whether or not he had a constitutional right to notice before she was adopted. He did not register. And if he had, he would have gotten notice under the statute. He didn't. The New York law at the time, relative to the putative father registry, required that notice be given to classes of possible fathers. One, people who are registered. People who have been adjudicated the father previously. Well, that wasn't his situation. If he'd signed the birth certificate, didn't happen. If they lived openly with the child's mother, held themselves out to be the father, supported the child, acted as a father, or married the child before she was 6 months old. None of that happened. So under New York state law, he wasn't required to get notice. He was the biological father. Did she know it? Probably. There's nothing in the case to indicate that she did not think that he was the father. He was with her. He was at the hospital when the baby was born. And this person did not get notice. And essentially the court said, the law protected you enough. It gives all of these classes of people notice. And then on top of that, has a putative father registry that you didn't take advantage of. So the court said, your due process rights were not violated, but you specifically did not get notice of this child, of this adoption. And in so doing, the court relies on the fact that the father didn't do anything to be a parent in the first 2 years of the child's life. If he knew he was the father, which he did because he was there in the hospital, he didn't give any support, he didn't act like a father, he didn't do anything. The court relied on that to say, you're not in the classes of people that we require notice constitutionally or statutorily. And then the court went on into an equal protection argument that the mother's rights were protected, but the father's rights were not. And the court said, you're in different positions. And one thing that I think is interesting is at the bottom of 861, the court says, parental rights do not spring full-blown from the biological connection between parent and child. They require relationships more enduring. That's true and it's not, because we all know that a biological connection to a child can render you responsible for support for 18 years. Just ask Kanye. He has a whole song about it, right? 18 years you have to, and longer into college, depending on the statutes in your state. It's not exactly what the court is saying. What the court is saying is that biology is not exclusive. It is not the be-all and the end-all. Just ask those guys in Minnesota who are now default parents who've never slept with the mothers of their children. And then on top of that, the court said, if you wanted to be a father to this child, you could have had a relationship with the child. You could have had some relationship with the child. You didn't. And so now we're in the position of telling the father who did, the stepdad, who did have the relationship, who wants to be a child to this father to this child, that he should not be. And the court, looking at the equal protection claim between mom and dad and between dad and stepdad, the court said that there was no equal protection issue either. It matters in this case that he knew the woman was pregnant, because knowing that she had a child, he could have fought for his rights earlier. He could have established a relationship with that child that the court would have then been in a different position. When you don't know, you can't establish your rights. You can't be the father to a child that you don't know exists. And those situations happen as well. There is a fairly famous one going on between the adoptive parents of a child and the biological father, who claims he did not know the mother was pregnant and so could not have asserted those rights. And it's slightly different, but it's a big difference. and we'll take a look at how the courts treated that. It's recently, I'll post that in your class as well. So that's the putative father registry and paternity, and now that's all of the content for week 1. Post your questions in the discussion board if you have any, and I'll get to them when I can. Thanks.